contract and do not agree to these proceedings. All right, so what do you want to do?
I'm here under threat, duress, and coercion. I'd like to say for the record, my name is Jamil of the Family Locker.
Let's get the record established. This is the city of Detroit versus Jamel Amir Lockhart. Appearance for the record, please, Counselor.
Rita White, House Counsel, on behalf of Mr. Jamil Lockhart.
All right, Mr. Lockhart.
No, no one is representing me.
Because this is one of those cases where confidence is doing all the heavy lifting and actual legal knowledge never even showed up to work. What you're seeing unfold is the internet law playbook in real time. Phrases pulled from forums, YouTube videos, and copy-paste documents that sound impressive until they collide head-on with an actual judge who knows the law inside and out. This defendant walks into court fully convinced that labels like flesh and blood man, special appearance, and no contract somehow grant him immunity from traffic laws, criminal procedure, and basic courtroom authority. And Judge Perkins? He's heard every version of this script before. What makes this case especially painful to watch is how quickly it spirals. Not because the court is unfair, but because the defendant refuses to engage with reality. Instead of resolving what should be a straightforward arraignment, he turns it into a slow-motion train wreck that ends exactly where these arguments always end, with the judge losing patience and consequences becoming very real. And trust me, the moment where this all finally clicks for the defendant, you don't want to miss it.
Go ahead, Mr. Lockhart.
Yeah, so I am Jamil of the Family Lockhart, flesh and blood, living man, and attorney in fact for Jamil Lockhart and Legis Trust. I'm here by threat, duress, and coercion. I'm here making a special appearance, and I'm here to demand that the court prove jurisdiction over me as a live flesh and blood man. As I said, I submitted a challenge to jurisdiction. Jurisdiction must be proven and proven on the record. And then also I submitted Freedom of Information Act request for your foreign registration statement and anti-bribery statement, as well as that of prosecutor. There is no contract. Every presentment that was made to me was formally rejected and sent back to the court, which is what you have a copy of, by my notary. I do have a live witness notary who can come in and testify to that fact. Given that there is no commercial contract, no commercial agreement, I fail to see how the court has jurisdiction. Furthermore, there's been no injured party, and there's been failure to state a claim through a verified affidavit. So if someone can prove to me how this statutory commercial court has some kind of jurisdiction over.
Is the first critical mistake, and it's a massive one. Court-appointed counsel is not a trap, not an enemy, and definitely not some kind of undercover agent of the state. House counsel exists for one reason: to prevent defendants from wrecking their own cases before they even begin. This attorney isn't there to force a plea or override your wishes. She's there to explain procedure, protect your rights, and step in when you start digging a hole you can't climb out of. But instead of using that safety net, the defendant immediately rejects it, convinced that self-representation plus internet legal theory equals control. And that belief is what drives everything that follows. Judges take self-representation seriously, but they also expect you to follow the same rules as licensed attorneys. There is no shortcut, no cheat code, and no magic phrase that suspends the court's authority. When you reject counsel, you don't gain power, you lose protection. And this hearing is about to become a textbook example of why that decision almost always backfires.
Well, let's start here. You have a notice is not what you think notice should be. Notice is what is if it's properly effectuated in the courtroom. And I'll certainly give you whatever hearing that you want if you file the proper motions of material to contest that. I'll give you an opportunity to be heard on that. But furthermore, what I'm looking at is I have a proof of service.
There is no proof of service. That that was rejected and sent back to the court. You have a copy of that.
You're not even listening. You're not even gonna listen. I listen to what you said. Are you gonna listen to me? Or you start making statements?
Oh, you had paused. I thought you were finished.
What it isn't.
Well, go ahead.
Are you giving me permission to go ahead now too, right?
I assumed you were done speaking.
All right. Listen, I have a envelope with certified mail. I don't know what I believe the contents have been stapled to the envelope. It's got a proof of service effectuated by Nyla Perrin. I have a signed complaint here, signed by Officer Randy Randolph on 11/19/2019.
Is he here today?
And we can get him in here. Today is only date and time is set for arraignment. So you're just being arraigned, and what the arraignment purposes of your arraignment, and let's go through the whole thing, is you're here for a expired plate ticket. That is a civil infraction that carries a $145 fine. There's an allegation that you did not have a drove while license not valid or improper. That is a misdemeanor offense, punishable by 93 days at the maximum by 93 days in jail and or $500 in fine. On the same day and time, it was an allegation that you did not provide proper insurance. That is a misdemeanor as it's written here, and that is punishable by the maximum possible penalty of 93 days in jail and or $500 in fines. There's also a warrant for your arrest for an allegation of an improper, not valid driver's license. So today is the date and time set for arraignment. You have the option of pleading guilty, not guilty, or standing mute. You stand mute, I'll enter a not guilty plea on your behalf. What would you like to do, sir?
I am here under threat, duress, and coercion to demand
You're
that
not
this
here under threat, duress, or
prove some kind of jurisdiction. And until jurisdiction has been proven, we can go no further. I would also like to ask you, is this proceeding taking place under common law?
This proceeding is taking place in accordance to the court rules and the statutory laws of the state of Michigan.
So I am not a creature of statute. I am not under statutory law. I would demand that this proceeding take place under common law, as I am a live flesh and blood human being, under no authority but that of God.
All right, I'm not going to go back and forth. I'm going to give you another court date. I don't have any All
I need you to do is prove jurisdiction.
You don't tell me what you...
This is where the sovereign citizen framework completely falls apart, and it always happens right here, jurisdiction. The defendant is convinced that by redefining himself as a live flesh and blood man, he can opt out of statutory law. But courts don't operate on philosophical identity claims. They operate on jurisdiction established by constitutions, statutes, and court rules. Michigan district courts have jurisdiction over misdemeanors because the Michigan Constitution grants that authority, and the Supreme Court of Michigan defines how it's exercised. The defendant's arguments sound complicated, but they're built on a misunderstanding of how law actually functions. There is no requirement for a commercial contract to enforce traffic laws. There is no need for a verified affidavit from an injured party in a statutory offense. And notarizing paperwork doesn't transform it into a legal shield. This is why judges don't debate these theories. They dismiss them, because jurisdiction isn't proven by arguing harder. It's established by law long before you ever walk into the courtroom.
And state in your case that the court doesn't have jurisdiction over you. In order for me to properly review that and go, it's got to be done according to the court rules. I need a motion, and I will read it. I will read that motion.
I have submitted a motion to dismiss for lack of subject matter jurisdiction.
I don't have it. I don't have it in front of me. And then I'll give you a motion.
I have a timestamped copy of this you'd like me to show you.
All right, you got to submit it to the court. Look at the.
It was filed by the clerk just 2 days ago. I have a
well, it hasn't
timestamp
gotten
copy
to the
of it.
file. It hasn't got to the file. I'm gonna give you another pretrial date.
I would like to say I do not consent. The court has to prove jurisdiction. I filed that document a few days ago. Anything short of that is an admission that there is no jurisdiction and we have no further business.
Still, did you have a question, sir?
None other than just stating that I do not consent to these proceedings and I do
You've
not
already
accept
put
any
that on.
contract.
You already put that on the record.
Okay, good.
You came back in.
I would also like to ask why this Mrs. Rita White had claimed to represent me.
All right, let's go back on the record with Mr. Jamil Lockhart. How old are you, sir?
I am 27.
You're 27 years old, and you go ahead and you ask why Miss White is here to represent you. Well, first and foremost,
Why did she claim to represent me and I have no knowledge?
I'll explain it to you. First and foremost, she's the House Counsel for this evening. So for this afternoon, she represents anybody who wants her representation as far as helping them to navigate and to defend themselves.
I have never expressed that want to her.
Why do you talk over people?
Well, I assume we were having a conversation. I'm sorry. I'll be quiet.
I am trying to have a conversation, but one's got to talk and one's got to listen.
Okay, go ahead.
You asked why Miss White said she represented you. Miss White said she represented you because she didn't know beforehand the position that you were going to take. So she's just merely
quite
doing
an assumption.
her job.
That is quite an assumption. Wouldn't you agree?
Well, by the name that you put up on there, Jamil of the family Lockhart,
That is
I wasn't surprised I wasn't surprised the avenue that you were going to take on that. Just by the name.
Recognize
But I
where
can't-
I'm from.
but she's not going to assume. I don't believe she's going to assume that she's going to treat you any differently than anyone else. And then you said that you didn't want her representation, and she.
Wouldn't you agree that for future reference?
This exchange highlights something even more damaging than bad legal arguments: complete courtroom dysfunction. The defendant isn't just misunderstanding the law, he's failing to grasp the most basic rule of any legal proceeding, which is that one person speaks at a time. Judges don't interrupt to dominate conversations. They interrupt to control proceedings. When a defendant keeps talking over the bench, it doesn't signal confidence. It signals inability to follow instructions. And judges notice that immediately. This kind of behavior isn't seen as passion or advocacy. It's seen as obstruction. Courts are structured environments with strict rules for a reason. If you can't demonstrate the discipline to listen, the court has no reason to trust you with procedural leeway. Every interruption chips away at credibility. Every accusation of not listening lands flat when the record clearly shows the judge responding point by point. This isn't assertiveness. It's self-inflicted damage.
Okay. Well, again, this whole time, there's a motion before the court to dismiss for lack of subject matter jurisdiction.
Well, there's not a motion
There has
before the
been
court.
what has been filed. I have a timestamp copy of it. I can show you that if you need to see it. But
Okay,
your clerk
let me explain
timestamps filed that document.
Let me explain to you. And this is just for your information. You say that you filed it with the court and the clerk down at the window, and I wouldn't disagree with that. But typically you want to, when you do your filings, that's why you want to have a judge's copy, and you want to specifically have that copy hand delivered to the judge's chambers. So we don't rely on the court clerks downstairs at the windows to make sure that these files get put into the proper place. You're not going to make.
Who do you
that
rely on for that?
You're making, and because you don't want to make that assumption that that file is going to get into the correct file. You don't want to make that assumption. Would you agree?
Who do you rely on to make sure that filed documents get into the right the right place, getting to
The person that's filing it, yourself.
court. It was sent to the court by a notary. So I do have a live witness to attest to that fact. It has also been time-stamped. That was recorded as well. I have checked all my boxes when it comes to notifying the court. I've also given you a demand for your Freedom of Information Act request for your foreign registration statement and your anti-bribery statement. The idea or the fact that you do not have that is an issue, and it would mean that you are committing a crime against me and holding this statutory proceeding and trying to confuse me as a live flesh and blood man, that I am a corporation beholden to the corporation which you represent. And that is my main point here today, is to tell you that I am not under your jurisdiction. I am a live flesh and blood man. You've already stated that this is not a common law proceeding. I am under no law but common law. We have no commercial contract which would enter us into any kind of statutory law.
Okay.
I fail to see the issue. And there's also no verified complaint with a signed affidavit.
Sir, let me stop you. And I'll let you put that on the record. I'll let you put it on the record already. We've already done.
This moment should have grounded everything. The judge clearly explains the charges, the potential penalties, and the purpose of the arraignment. This isn't a debate forum. It's a procedural step designed to inform the defendant and move the case forward. And notice how patient the court still is at this stage. The judge lays out options calmly. Plead guilty, not guilty, or stand mute. That's it. Simple. But instead of engaging with that reality, the defendant retreats right back into jurisdiction demands and philosophical objections. And that's the fatal flaw here. Courts don't stop functioning because a defendant refuses to acknowledge them. Procedure continues whether you consent or not. Arraignments happen whether you agree or not. And ignoring that reality doesn't halt the process. It just removes your influence over it.
Statement. That's an admission that you are here as a criminal actor.
Okay, sir, I'm gonna end the hearing now.
And I do not consent to any further hearings on this issue or this matter. We have no valid contract. We failed to prove jurisdiction. There is no valid claim.
All right,
I do not consent.
That, sir. I've already let you make a record, and I don't want you to mention any more because I'm gonna hold you in contempt of court. Okay, so I let you make your record. I set a date.
Whatever you feel like you need to do. I'm here to tell you that I am not under your jurisdiction.
All right, have a great day. And it seems that you really need an education on how this stuff works, and I'm gonna give you one today. 5-7. People of the state of Michigan versus Ibrahim Abiola Alatubasan. Defendant is charged in count 1, criminal sexual conduct, first degree, person under 13, defendant 17 years of age or older. Count 2, criminal sexual conduct, first degree, person under 13, defendant 17 years of age or older. Count 3, criminal sexual conduct, first degree, person under 13, defendant 17 years of age or older. Appearances for the record, please.
Good morning, Your Honor. Erin Wilmoth, P82085, appearing on behalf of the people.
And good morning, Your Honor. Nicole James, appearing on behalf of the defendant. My P number is 58961.
All right, so we have the defendant who's also present via Zoom from the county jail. I have him on mute because I wasn't successful in getting him to shut up this morning. So the record should reflect that he is present.
Yes, Your Honor. I will acknowledge that he is present.
I'm sorry, go ahead.
No, I was just acknowledging that he is present via Zoom.
Okay. Today is scheduled for a competency hearing.
Next second, where things cross from misguided into dangerous. You never tell a judge what they need to do, ever. Judges control scheduling, rulings, and courtroom authority. The only acceptable way to challenge jurisdiction is through a properly filed motion, not verbal demands, not interruptions, and not confrontational instructions. When the defendant speaks this way, he's effectively daring the court to assert authority. And courts always win that contest. This is where contempt becomes a real possibility, not because the judge is offended, but because courtroom order is being challenged. Freedom doesn't vanish randomly. It erodes through choices like this. The judge is still offering process, still explaining next steps, still extending patience. But the margin for error is shrinking fast.
And that they believe it could be restored with treatment. But I don't know that we've received anything else unless Ms. Wilmoth has something.
No, that's my recollection as well. He was referred for competency. If the court recalls, he was refusing to put on his clothing for court. So Ms. James and I both joined in a request for competency. I have not received any report as to a status update as to treatment.
I have one dated May 23rd. And it's their opinion that the defendant has been taking medication and reported some improvement. If he continues to remain in treatment and demonstrate improvement, it is their opinion that he could be restored to competency within the statutory time period.
I'm not in receipt of that report, but thank you.
May 23rd.
I'm sorry, Judge, I didn't hear what you said.
It's dated May 23rd.
Thank you. And I'm not in receipt of it either. However, I would ask at this time that the court order that he continue in treatment and taking his medication.
Okay. Hey, Deputy.
How you doing, Judge?
Good morning, sir. I'm ordering that the defendant in contempt of court.
You need to get fingerprinted. You keep refusing. Yes, sir. I'll let my sergeant know, Your Honor.
This case is dismissed. This case is dismissed. I don't need any lawyer. The case is dismissed already. This is the document for it. The case is dismissed. And did not allow me to move out of this YNJ County jail. Why?
As I explained to you before, sir, that's a different case with the same complaining witness.
It's the same name, Damara Andrew.
Judge, may I shed some light on this?
Yes.
I need a report.
Thank you. So this was a case that I inherited from another prosecutor as being trial ready. It was set for trial, and as I was preparing for trial, there was certain items of discovery, including body-worn camera and medical records that had not been received by the previous prosecutor